Well, good morning, everybody. Thanks for joining us for this this webinar today. We've got a number of people out there. Probably we're broadcasting to about 250 people out there. So I'm thanking everyone for joining us on our latest subrogation webinar, and look forward to talking to you today about the made whole and common fund doctrines. But before we get started, before we get started with the presentation, I wanted to review a few housekeeping items and let you know exactly how you can better participate in this in today's webinar. The current screen that you're seeing right now, we are looking at an example of the GOTOWEBINAR attendee interface, and it's made up of two parts. The viewer window is where the attenders see the presentation, so that's right over here. And then the viewer window, it can be resized in your own browser by clicking and dragging the lower right corner. And then the control panel over here is where you can interact with myself and the organizers here over at Matthiesen, Wickert Lehrer. I'll refer to this for now as the grab tab. So as you can see, that's what I'm talking about. The audio pane provides audio information. If anyone is having difficulties hearing, you're going to want to go check your audio pane setting. Or if you're having difficulty speaking, you're going to want to enter the that section. Make sure that you're either using your telephone, using your computer and speakers, and that you've entered the correct audio pin. And then as we go on, you're going to have the opportunity to ask questions. Sometimes I will have an opportunity to glance down and check out everyone's questions. If something pops up that I need to address, I'll try to do that. Otherwise, we'll be collecting your questions, and we'll try to get through some of them at the end of the presentation. But what you can do then is just type in the questions, and then I've got someone who's going to be collecting them, and we'll make sure that we try to address as many questions at the end of the presentation as we can. So that's kind of how that's going to work. Why don't we kick it off with the presentation? First of all, I think a lot of you know who we are. A lot of you are clients of ours and have worked with us for a number of years. Matthiesen, Wickert Lehrer is a national subrogation firm based in Wisconsin. Although our lawyers are here in Wisconsin, we practice throughout the United States, Mexico, and Canada. As you can see, the little dots on the map to our left basically represent those local counsel that we work with around the United States that we've got contracts with to do the subrogation work on a national basis. So even though I'm sitting in Wisconsin, I've got cases all around the country that I'm working on with you guys for, and looking forward to more work. But what is the focus of today's webinar? I didn't want to get too, because we're talking about the made whole and common fund doctrines. So I didn't want to get too bogged down with self-funded ERISA plans. We will certainly touch on those throughout the presentation, but they're not going to be the focus. What the focus is going to be for state law-driven subrogation. A lot of it's going to be your health insurance, occupational accident insurance, and to some degree, it's going to be workers' compensation subrogation in those made whole states, like Montana and Georgia. So that's going to be the focus. If you guys are dealing with state law subrogation issues as opposed to self-funded, that's what we're going to focus on. We're going to get into all of the kind of the state arguments under the made-whole doctrine and tell you about them. You know, it kind of go through what the arguments are and how you can best respond to those arguments. So why don't we begin kind of getting into the presentation. One thing that I always like to do on my subrogation presentations is remind everyone why we do what we do. And I think this is so often missed in subrogation cases, and it's an argument I try to make in all of my briefs, whether it's to state or federal courts on the issue, is to get into subrogation before we get into the specific case. Just, you know, to inform the court, you know, what exactly is at stake here, why are we subrogating, how does it affect other members of the plan or other insureds under this policy. And so to do so, I kind of look at the statistics. Obviously, everyone knows that we are in really a health cost crisis based on the way that health insurance costs have continually increased year over year. And as you can see, since 2001, the health costs have increased 78%, with a 17% increase in the cost of living. So obviously, health costs have by far outpaced inflation and the cost of living. So we as insurers, as self-insureds, we are dealing with having to increasingly pay out more and more on health claims, and obviously that increases the contribution rates from our members or the premiums that are paid. And so subrogation, as you can see, is going to represent one key thing that we can do, that we can actively do to make a difference in making up for those dollars, those increasing dollars that are going out. And it's explained this way. Basically, revenue is anything, any money coming into the insurer, whether through subrogation, premiums, or anything, is applied toward responding to the actual risk that is required to be paid by the insurer under the terms of the contract. So what does that mean? Basically, as the insurer takes in subrogation dollars, the actuaries will make a calculation based on next year's potential risk. That means what they'll be paying out potentially, and base that on last year's recoveries. So subrogation always is factored into the actuarial accounting risk going forward, and it can certainly help keep down premiums and in some cases even reduce premiums going forward. In self-funded plans, it's a little bit different in that when the money comes back in from subrogation, those dollars are actually just turned right around. If they come in from, you know, Joanne's car accident, you know, recovery case, they will be going out to pay Steve's broken leg. So it actually turns right around, and you can see the difference right there. Generally, between 3 and 5% of all of our paid claims are going to have subrogation potential. Obviously, that's going to vary by what kind of product you're writing, who your pool of insureds are, and in what state you are. But that's a very a general number that we've been seeing around the country. And then obviously, keep in mind, you know, catastrophic claims can really have a significant impact on especially smaller companies. They have a tendency to raise our risk modifiers, and they can severely escalate premiums. That's why it's so important that we focus on how we can recover those dollars through subrogation. And I use this general subrogation introduction, like I said in my briefing, with the judge that I'm dealing with, so that they understand what we're facing, and that it's not simply about this particular case or this particular injury. And that's why it at least makes it a little easier for the judge to put that in context, especially when he's being asked to extinguish the subrogation lien based on the made-whole doctrine. So what is the made-whole rule? Well, it depends on where you are. But basically, just generally speaking, it's either a judicial or a legislative mandate. So it either comes from the courts or it comes from the legislature, that an injured claimant must be fully compensated for all damages before a subrogated party may collect. Essentially, it is just a rule of priority. As another author put it, when the pie isn't big enough, who eats first? And courts around the country, legislatures have made their determinations that it should be the injured person who gets to be compensated first. And we can agree or disagree on whether those courts were right or those legislatures were wrong, but that's what we're dealing with. And basically, the thinking is that the individual has gone through, paid the premiums for the insurance coverage, so he or she should be getting the entire benefit of his bargain, which is he should have the right to recover all his damages before the insurer is then allowed to come in and take a part in that third-party recovery. But there's many different variants of the rule. I don't want to leave you with the impression that the made-whole doctrine is the same everywhere in the country, that simply holds that the plaintiff has to be made whole before the insurer can subrogate, because that's not necessarily the case in all the states where the made-whole doctrine is applied. You've got to know what you're dealing with in the jurisdiction that you're dealing with. So, some of the questions that we'll look at and try to answer today is where does the rule come from? How big does that pie need to be before I can recover it? Does the made-whole, or how do you measure the pie? That's another key question. How does the made-whole rule apply to? Does it apply to every category of damages? In other words, when we talk about our health insurers paying medical expenses, does it require that your plaintiff, your claimant, your insured recover just the medical expenses first before you can subrogate, or do they have to recover all different category of damages that they have before you can subrogate? What about the idea of the plaintiff's own contributory negligence? How does that factor in? And we'll get into that in a little bit. Do I need to consider the plaintiff's attorney fees with regard to whether he's been made whole? Now, later on, we're going to concentrate on the common fund doctrine, but as you'll see, this is actually a separate question as it relates to the made whole doctrine. And then finally, can my subrogation provision override the rule? And I think that in some cases we'll be surprised as to that answer. So what exactly is the legal authority for the make-whole rule? And I might refer to it as the make-whole rule, the made-whole rule, the full compensation rule. It goes by a number of different names, but make-whole or made-whole is essentially the industry standard, or what we're talking about, what is well understood to be referring to that principle. There's a couple different bases for the law, and one, the first most powerful authority for the law is statutory law. And statutory law, again, is something, a bill that was passed by a state legislature, signed by the governor, and entered into law. And as you can see, Colorado and Georgia are two examples that have a codified made-whole rule. And I've got the citations there. Colorado's is very new. It has not actually been really tested yet to the extent of how it's going to apply. Georgia's has been around for a number of years, and it specifically does not permit subrogation unless the insured has recovered all of his categories of damages. So that's one authority for the made whole rule. But the second authority is what's called just common law. Essentially, some court who got a case in front of it involving an injury to an insured and an attempt at subrogation made a decision. A handful of judges would make the decision that it is the law of this particular state, even though it's not written or codified anywhere by a legislature, that the insured, again, has that first priority to be made whole, fully compensated, before the insurer can step in. Now again, the main justification is going to be that, you know, the insurer is in the business of assuming risk, and the insured has paid premiums, and so the courts deem it somewhat inequitable to allow the big insurance company to come in and step in and try to subrogate before the little guy has been fully compensated. So we're not going to necessarily, you know, take up issue with that reasoning today. Just know that that's what it is, and that's where it comes from. In addition, there is federal common law in addition to the state common law. So if you're in a federal court, the federal judiciary has basically adopted in some circuits the made whole doctrine as a default rule. The 6th, 9th, and 11th are examples of federal circuits, if you're in federal court, that apply that as a default rule. And we can talk about what language is necessary to get around that default rule. Other courts have rejected it as a default rule. You just need to know exactly what circuit you're in and whether they've adopted that as a default rule as it comes to your case. Subrogation versus reimbursement. This is an important concept for us to get our arms around, because subrogation and reimbursement are used so interchangeably in the industry and even in the court cases, that it's important that for discussion of the made whole doctrine that we understand which one we're dealing with when we talk about it. Subrogation really is the general term for what we are doing when we are recovering money from a third-party settlement or judgment. But it doesn't quite accurately describe every situation we're dealing with. Subrogation, on the one hand, describes our efforts at directly pursuing the third-party tortfeasor. So that would encompass you as a claims handler sending out, for example, a demand letter to the at-fault party or the at-fault party's insurance company and requesting that they pay you back for what you've had to pay in medical expenses or disability expenses, excuse me. And that is really, it's you versus a third-party tortfeasor. The insured is really not part of that process when we talk about subrogation. Essentially, you are, as they like to call it, stepping into the shoes of your insured. You're inheriting, their claim, their rights, but they're not really essential to the process of subrogation. Reimbursement, on the other hand, is the concept that we're going to probably hear more often than not when we look at these made whole decisions, describes our demand that our insured repay us after they went out and made a recovery. So basically, reimbursement is when we are sitting back in our office. We haven't really engaged in subrogation directly against a third party, but we know that our claimant or our insured has. They went out there, they either sent the demand, hired an attorney, filed a lawsuit, and then they made a settlement, or they went to trial and they got a verdict, so they've been compensated to some degree for the accident. And part of that they recovered includes compensation for those medical or disability expenses that you have paid. And so what you've then done is sent a letter to your insured or his attorney demanding that you be repaid for what you've paid. So that's the reimbursement concept, and the insured is essential in the reimbursement concept, but the tortfeasor isn't. So the tortfeasor is not directly involved in your reimbursement claim. And it's important because there are a number of authorities out there that are going to tell us that the made-whole doctrine has no effect where you are actively out there pursuing subrogation against the tortfeasor as opposed to reimbursement. Now that rule can be changed a bit if we're dealing with limited policy limits, or we're dealing with limited collectability. But let's assume that there's a sufficient pool of insurance out there to cover both your subrogated claim and the insured's uninsured out-of-pocket claims, then the made-whole doctrine is not going to have any effect. And the difference is, in those cases, when you're subrogating against the tortfeasor, public policy really wants to hold the tortfeasor responsible. The at-fault party should be forced to pay for all the damages that at-fault party created. And that includes your subrogated claim. So as long as there's enough money out there to satisfy you and your insured, we don't have to worry about the made-whole doctrine. The problem comes in is when we're not out there actively subrogating. We are essentially relying on our reimbursement rights against our insured should they make a recovery. Then what happens is that your insured is in charge of making sure that they recover an adequate amount from the tortfeasor. Instead, what ends up happening is that typically in all of these made-whole cases is that the insured goes ahead and settles for less than the total value of his or her case. And there might be many good reasons for that happening. But then when we go against our insured requesting reimbursement, the insured has the defense that they have not been fully compensated. And so that's where we're mainly going to be dealing with the made-whole doctrine. So again, if we remember that we can subrogate in a lot of these jurisdictions, we're going to be in a much better position with respect to the made-whole doctrine. Next, what elements of damages does the made-whole rule apply to? And this is where I get into the question of what exactly is the size of the pie, and how do we measure the pie? Because as you all know, if you are out there paying medical expenses, disability expenses, that's only part of the total amount of damages that your insured or the plaintiff is going to be able to recover in a case. Medical expenses and lost wages or disability type benefits, those wage replacement benefits that are often paid, are two of the main components, and they're very strong categories of damages because we can put a precise dollar figure on them, but they're not the only ones. In many states, you can recover compensation in a lawsuit for, scarring, disfigurement. In every state, you're going to be able to collect for pain and suffering damages, and there's no precise science in calculating what a person's pain and suffering is. It's this intangible kind of number out there when we try to put a number on it, but we have to put a number on it. The jury will have to put a number on it. There's going to be damages for future medicals. Maybe you are or maybe you aren't, as a subrogated insurer, on the hook for future medicals. Future lost wages, future loss of earning capacity. So there's a number of different categories of damages that a plaintiff will be able to recover, and then that leads to the question of, does the plaintiff have to be fully compensated for every single category of damages before we can seek reimbursement or subrogate for the medical expenses that we've paid? Well, one way to answer that question is that the Rimes court is a very famous. The Rimes decision is a very famous decision in Wisconsin, and basically what our courts have held is that the insured needs to be completely compensated for all the elements of damages, not merely those damages for which the insurer has indemnified the insured. So in Wisconsin, or very similarly in Georgia, which has the statute we cited earlier that has basically the same language, the insured is going to have to recover for every single category of damages before you can step in and say, I have a right of subrogation. So that's difficult. That makes subrogating a lot more difficult, and it also creates an incentive for potential misallocation between the different categories of damages. You know, I mean, it allows the insured to kind of puff his number of damages. On the other hand, there are some decisions going the other way. For example, in Iowa, the court basically disagreed with the Wisconsin court's decision and basically said that once the insured is compensated for the damages that is covered by the policy, then the insurer can subrogate. So, for example, the insured may not get all of the lost wages that he wants in his lawsuit, or all of the pain and suffering damages he wants. But if he recovers all of the medical expenses in the settlement or the lawsuit, then you can go ahead and subrogate. And this is going to come, you know, obviously we run into problems when cases are settled without an allocation between the different categories. But in cases that go to a verdict, there's going to be on the verdict form, all these different categories of damages are going to be put on there, and so the jury is going to award. Whether the jury award all the medicals, we'll know. We will know precisely, and then we will be able to argue that, well, I know the jury didn't give you all the lost earning capacity you thought you were going to have going forward, but they did give you all the medical expenses. Therefore, my subrogation lien or reimbursement lien attaches to this judgment or settlement. So those are two important concepts. That's an important concept there that we've got to understand which way the jurisdiction that we are in goes on that issue. Because if it's a rhymes jurisdiction, it's going to be much more difficult for us to recover through subrogation in that made-whole jurisdiction. On the other hand, if it's an Iowa-type jurisdiction, we're going to have a much better argument on the made-whole doctrine. Next, what is the effect, if any, of contributory negligence? If you've been involved in negotiating auto accident cases or you've got a subrogation claim, you know that in almost every single case, there's an allegation that our driver was at least somewhat responsible for the accident. You know, you almost get a couple % just by being in an auto accident. You know, someone said you didn't keep a proper lookout, or you know, someone alleges that you were going a little bit too fast. You know, it's going to be an issue in most cases that we see. So, how does the made-whole doctrine accommodate for contributory negligence? On one hand, you know, there's an argument, and unfortunately, my state is not exactly the most progressive in our favor. In fact, they're one of the most progressive at opposing our right to subrogate. Essentially saying, look, if the insured has been found contributory negligent, the court needs to consider that when it seeks, when the insurer seeks to subrogate. So, for example, if the insured is found contributory negligent, that insured cannot recover all of his damages as a matter of law. For example, if he's got $100,000 in total damages, but he's found 10% at fault, he can only recover $90,000. So the plaintiff's bar in our state, and in many others, will argue that, well, look, he's contributory negligent, so as a matter of law, we can't recover 100% of our damages, and therefore you can never conceivably ever subrogate. Now, practically speaking, we don't always have that that effect because most cases are settled before a jury makes any kind of a finding of contributory negligence. But that argument is certainly out there. There is also a counter argument, basically saying, no, contributory negligence does not have that preclusive effect on a case. What it does essentially is limits our capacity to subrogate by that same degree. Remember, we're stepping, one of the ways of describing subrogation is that we're stepping into the shoes of our insured. We get the benefits that they get, but we also get the drawbacks that we're stuck with. And if our insured is found 50% at fault, we have to basically eat that 50%. We can only recover 50% of our damages against that tortfeasor or from the insured settlement. So essentially, there are two schools of thought on this. It's going to be very important, again, that you know what your jurisdiction says on this particular issue. I think that the minority rule is going to be kind of espoused by the Wisconsin court here, in that the insured, is essentially not made whole because he's found contributory negligent. The majority rule is essentially that you are going to have to reduce your claim by that same share of comparative fault. But one of the worst states, if there's any worse states than Wisconsin or Georgia, Montana has to be the most negative subrogation state in the country, and it's by far. It's not even close. I mean, I love Montana, don't get me wrong. I vacation there every year. It's fantastic. I would encourage everyone to go to Montana to visit. But as far as subrogating in Montana, we are really, really facing an uphill battle. And technically, subrogation, I mean, Montana is not an anti-subrogation state to the extent that there's a statute that bars subrogation per se, but it applies a very, very strict version of the made whole rule. Essentially, what Montana says is that subrogation is against the public policy of Montana if it occurs before the insured is made whole. Now, that is no different than Wisconsin or Georgia or many other of these made whole states that we'll focus on. But what Montana says is that the made whole doctrine and the full compensation rule applies to attorney's fees, which is kind of crazy because it kind of goes against, the American rule that each side is responsible for his or her own attorney's fees. But it practically speaking makes it impossible for us to subrogate unless the insured goes to trial, recovers all the damages in a verdict, and the jury, for some reason, is allowed to award attorney's fees. So, using our $100,000 as an example, if the insurer recovers $100,000 in an auto accident, and that happens to be the total amount of damages, that insured is still going to have to pay that 33% to their attorney. So they're only going to be recovering $66,000 at a maximum out of that $100,000, and $66,000 is not $100,000. So Montana says, nope, they haven't been made whole. Essentially, they have to recover $133,000 on that same $100,000 case, and that makes things very, very difficult for us in Montana. In addition, I want you to be very, very, very careful when we're subrogating in Montana, or at least attempting to subrogate in Montana. Everyone's first inclination is to send a demand letter out there to the tortfeasor and send a notice letter to the plaintiff's attorney regarding your lien. I would make sure that you don't call it a, quote, lien in your letters, because what the plaintiff's bar in Montana is very famous for is turning molehills into mountains. And what they will do is not only just consider filing a bad faith or a breach of contract action against you for sending out a subrogation demand, or demanding subrogation out of a settlement, they will turn it into a class action lawsuit. All of a sudden, it goes from a very, very minor subrogation claim in someone's office in Kansas City, Missouri, to the head of the company because you've been sued in a class action lawsuit. So I want you to be very, very careful. What you've got to do, what actually Montana requires that you do before attempting to subrogate is conduct a, quote, made whole investigation. So essentially, before you send out that letter saying that they are required to repay you your subrogation claim, or asserting that you've got a lien on their settlement or case, you've got to send out or call the plaintiff's attorney and get information that would allow you to make a determination as to whether your insured has been made whole. And that includes, well, what are the total damages being claimed? How much are your attorney's fees? How much are the policy limits of the other side? What was the settlement for exactly? How did it allocate for? You've got to ask all these questions. Otherwise, you run the risk of potentially being sued for bad faith. And obviously, no one wants to be sued for bad faith on a trying to just merely attempting to collect on a subrogation claim. Fortunately, I don't think most people are going to get caught into that trap. In this case, the Bolin case, the attorney, I believe, attempted to sue for because the insurer had sent, the subrogated carrier had sent a demand letter to the tortfeasor, basically asserting its subrogation rights. But the court basically found that that was not enough to show that they hadn't conducted essentially a made whole inquiry. But there are other ones, to be careful of. If you make demands against your insured or claim that you filed a lien on their settlement without conducting or asking the questions about whether they've been made whole, I would be very, very careful. So again, you've got to conduct an affirmative made whole investigation. Don't send out letters that have a, quote, notice of lien. You can certainly notify them of your subrogation claim or your potential subrogation claim, and then conduct your made whole investigation. I just would be, concerned about putting anything, that says lien on it. And the Kramer case, the Kramer case was the one where the court held that the notice of subrogation is permissible under the made whole investigation requirement. So what exactly are we to do in these strict made whole states like Montana? Well, I took a really good look at Montana, previously for some cases that I've been involved in, and there's really, most of the facts that we come across are simply not going to be sufficient for us to make a good argument that the insured was made whole. I mean, I'm still looking for that perfect case to kind of take up and challenge the made whole rule in Montana. I haven't seen it yet, and I, don't want to give anybody bad advice or false hope. So, but one of the things that you can do in Montana or some other of these states like Wisconsin that are strictly made whole is to rely on exclusions, offset or credit provisions that you might have in your policy. And what do I mean when I say that? Basically, what I'm saying is not paying benefits in the first instance is better than a subrogation recovery. So if we have the ability to essentially offset what we are required to pay under our policy because of a recovery under another coverage or even from a third party, and then not pay future benefits, the courts view that a little bit differently than they do us trying to actually enforce our subrogation or reimbursement claims from the settlement. So essentially, if we're just enforcing an exclusion that says we don't pay benefits if you've already recovered those duplicate benefits, from another coverage or another insurer, the courts will enforce that. So those are things that we want to investigate as to what other potential coverages are out there. Can we coordinate benefits with making someone else primary and then not have to pay that additional coverage or those additional benefits in the future? That's the best argument that I can come across in some of these states. Another argument that has not really been tried, but I think that there is some really good arguments to be made out there, is a choice of law argument. And I make these choice of law arguments every day because I've got some really good clients who have had the ability to put choice of law provisions in their insurance policies. So, for example, the policy will essentially say that it is governed by the laws of Illinois where it was issued and delivered. And a court will, generally speaking, uphold those choice of law provisions under a choice of law analysis. And in Montana, in particular, although it's not really been tested, one of the most recent cases in Montana is this Blue Cross Blue Shield case, where it essentially disapproved of a third-party auto liability exclusion for, now I know this kind of looks like it contradicts with what I just said earlier, but that was for health insurance issued in Montana, covering a Montana insured. But many of us cover truck drivers, for example, under our policies, and they're going from state to state. They just happen to, as a matter of chance, be in Montana when the accident happened. Obviously, the Montana insurance commissioner who made this initial decision that was challenged doesn't have authority to implement regulations or rules governing insurance policies that were issued and delivered in another state. So I think there's a very strong argument that we can make, and that's even if your policy doesn't contain an express choice of law provision, that if the policy was issued and delivered in another state, that contract law of the other state should apply, and we should have a right of subrogation. Now, again, it really hasn't been tested in Montana. I think it's a very good argument that can be made in conjunction with, like I said, the perfect case where we can also argue potentially damages under a pure made-whole type trial. But again, these are just arguments you can use. I would be very careful. Feel free to give me a call if you're dealing with cases in Montana to run by whether you've sent the right letter or whether you're potentially saying something you shouldn't in your letter. But there are arguments. No matter what state we're in, there's always going to be arguments, and consider choice of law as one of the arguments. Also consider using exclusions or offsets to limit your future liability in those states as well. I told you I'd hit on ERISA plans very briefly, and I will. ERISA, and it goes for FEBA too, those federal employee benefit plans. Essentially, the law is very, very favorable. Federal law allows an ERISA plan to expressly override application of the made-whole doctrine as long as there is basically some specific direct language that does so without ambiguity. So one of the latest cases on this has been the Zurich versus O'Hara case in the 11th Circuit, and in that case, basically, the provision expressly allowed the plan to seek reimbursement regardless of whether the covered person was fully compensated or made whole. And that's great. I mean, so what you need to do, you don't always have to say made whole. You don't have to reference it specifically in your policy. It's great if you do. But you basically need to specify priority. This goes back to the beginning. Made whole is a rule of priority. So if we specify that we have a first priority right to subrogation and reimbursement, That's going to be sufficient for us to disclaim that doctrine. Now, some states, now we're back to the state law. Some states allow insurers to contract around the made-whole doctrine. So this is for your non-ERISA plans. This is, can we enforce that great language we've got in our policy, or will the state law still trump that insurance, that contractual provision? There's a number of states. Wisconsin is one of them. Arkansas is another here. I've cited the Arkansas case that unfortunately say it doesn't matter, insurer, what you put in your subrogation provision. It's against public policy for you to contract around the made-whole rule. So that's no good. But there are other cases. Peterson versus Ohio Farmer, it's an older case that's been upheld. Fortis Benefits versus Contu down in Texas, which is just a fantastic case. If you don't have that printed out for your use down in Texas, you should print it out and get it. It allows the court to contractually override the made-whole doctrine by the insurer simply asserting a first priority language in their subrogation provision. It's fantastic. There's a number of other states that will enforce contractual overrides, even under state law. So we're not dealing with ERISA. Again, we're just dealing with the state law that will still allow an insurer to contract over it. You need the first priority language. I prefer that you also have something in there that says that you've got a right to subrogate regardless of whether the person was fully compensated. But that's another thing. You need to know what state we're dealing with, what jurisdiction are we in, and can our contractual provisions override the made-whole doctrine that would otherwise apply. All right, now we're coming up to a couple more clever arguments, and they will work in some jurisdictions. They will not work in other jurisdictions. One of them is that basically a settlement or a verdict will completely defeat the made-whole argument. So if the plaintiff willingly settles his case, there are courts that will hold that a settlement and a release of all claims presumptively makes the insured whole. This is a new case that came out recently in Indiana. I think it's very helpful because that state has a lien reduction statute that we have to worry about. So I'm very pleased with the language in that decision. Other courts have held that, well, it's not just any settlement. It has to be a settlement within the tortfeasor's policy limits in order for that to be presumptive. There's a number of cases here. In addition to even the Colorado statute holds that a settlement within the policy limits issues a rebuttable presumption that the plaintiff has been made whole. Finally, what about a jury verdict? Absolutely. A jury verdict is the final say on what amount compensates the plaintiff for his alleged damages. So we don't have to go about arguing about whether the plaintiff has really sustained $500,000 in future earning capacity loss or $200,000. We go with what the jury says. So if the jury puts an award down, the majority of courts, and there's 4 I've cited around the country, have held that that completely defeats the made-whole doctrine. So whatever is put down by the jury is going to completely compensate, so you will be able to subrogate in those jurisdictions. But what about if we don't have a presumptive settlement state, or there's not a jury verdict, but there's been a settlement and the plaintiff is still arguing that the settlement doesn't make him whole? How exactly do we go about calculating made whole at a damages trial? And that's really kind of what's going to happen. Is a number of states, whether it's Georgia, Wisconsin, Tennessee, as this example will show, what will happen is that the plaintiff will settle his case. He will say, whatever amount of money I settled for doesn't make me whole. And there will be an opportunity for the insurer or for the plaintiff to then have a subsequent hearing. So it's like a post-settlement hearing on whether he's been made whole. It's like a mini damages trial. It's very important that we get the calculation correct, because the plaintiff will make this rather appealing argument that will say, well, I know that the insurer has paid $50,000 for my medical expenses, and my total damages are $150,000 when it's all said and done, but I only recovered $100,000 in my settlement. Therefore, I'm presumptively just not made whole. Well, that's not exactly the correct way of calculating or even looking at made whole. This case is fantastic. I'm sure it wasn't fantastic for the lawyers who litigated this case for the good part of 10 years and for, Court of Appeals, Supreme Court decisions, and then back and forth from the trial court on this case. But ultimately, the court does articulate a better way of counting damages to determine whether the insured was made whole. So let me just go through it real briefly. In this case, the plaintiff received a little under $38,000 in benefits from Prudential and $7,000 from another insurer, received a settlement of $100,000 for a total recovery of $145,000. So look what the court is doing. The court is not saying, I know that you've recovered $100,000 and you've got 37 plus 7, so 43, 44, about 45, about, I guess, in subrogated claims. Have you been made whole? No, no. What the court says is, well, you've received $100,000 from the tortfeasor. You've also received $7,000 from BMC and $37,700 from Prudential. So we add all of that together before we determine how much you've recovered. So essentially, your subrogated claim gets added on top of the third-party recovery for purposes of how much has been recovered by the plaintiff in the case. So unless he can show that his total damages in the case exceeded $145,000, the insurer is going to have a right of recovery. And so it's very, very important. Take a look at that case and how they add it up. They don't simply say, well, I know you've recovered $100,000 from the liability policy. That's your total recovery. The court views the total recovery as liability settlement plus subrogation amount. So that's going to increase the plaintiff's recovery. So he may say, well, I've got $100,000 in damages or $120 in damages, but I only recovered $100, so I'm not made whole. By this court's counting, he's actually recovered $145, so he has been made whole. So it's going to be very important that we argue that the court has to add up all settlements, all recoveries from all sources in determining what the total damages are that have been recovered as part of a made whole calculation. Very important case. Take a look at it. If you don't have it, I'd be happy to provide you a copy with it after the presentation. Let me just give you my final just tidbit thoughts on the made whole doctrine. Well, the most important thing that you've got to do is know your jurisdiction. I can't emphasize this. You can't treat each subrogation claim you have as the same. You can't treat each state's made whole doctrine the same. You've got to know the jurisdiction. You've got to know exactly how they treat the made whole doctrine. It will entirely change how you make your arguments, what arguments you select to make, whether you need to make a choice of law argument. So you've got to do your homework before you even send out that first letter to the parties. And again, pick your battles. Bad facts will make for even worse law. I mean, Montana is a good example of getting yourself in trouble by getting yourself sued for a bad faith suit where you pursued subrogation or reimbursement when your insured hasn't been made whole because maybe you didn't understand how their made whole doctrine worked. That's one. Also, I mean, if you've got a bad catastrophic case, it's going to make it very, very appealing case when we're dealing with state law made whole. So pick your battles. If you've got good facts and you've got and you want to go up against it, if there's been a massive recovery inside of the policy limits, and you've got a modest lien, let's go after it, you know. But if we don't, we've got to be very, very careful. So I know that I'm coming up on an hour and a couple minutes here. So I'll kind of cruise through the common fund doctrine part of the presentation, unfortunately. But again, I want to remind everybody, if you've got questions, send them to me afterwards. I will make sure that we get to them and try to answer them. I've also got whatever questions have been submitted, and I will try to get back to those people after the presentation directly. Okay, what is the common fund doctrine? It's essentially an equitable doctrine that is designed to prevent unjust enrichment, and it applies. What we're talking about is attorney fees. We're talking about the principle that you, as a subrogated insurer, if you haven't participated in the trial, if you haven't been represented by an attorney in pursuing your subrogation claim, and the insured's attorney has done so, well, equity allows them to take a fee out of your recovery. And we're going to focus here just on the common law common fund doctrine, as opposed to some states have a statutory or legislatively driven common fund doctrine like Iowa. We're not going to focus on that. If you've got a statutory common fund doctrine, you've got to simply look at the statute that you are dealing with and try to deal with that. Finally, here, one of the keys, though, before the common fund doctrine can apply in any particular case, is the plaintiff's attorney has to give you notice. So you've got to have notice of this pending action and the opportunity to retain your own attorney, to intervene, to try and protect your own interests, as opposed to allowing the common law to allow the plaintiff's attorney to simply take a fee. They've got an obligation to give you notice and an opportunity to join the action if you want. ERISA plans, FEBA plans, we know that they can disclaim the doctrine, but you need crystal clear language that essentially your plan does not pay, nor is it responsible for the participant's attorney's fees. Pretty clear, self-funded ERISA plans, you've got great rights. You don't have to worry about some of the other things we'll talk about. The main defense that we're going to have to a common fund claim is the active participation defense. So after we've received that notice of the lawsuit, we are going to have the opportunity to retain our own counsel, to intervene, and try to, quote, actively participate in that litigation. But again, the common fund is treated differently. The active participation defense is treated differently by different states. And so what constitutes active participation in one state necessarily won't translate to the next state. So for example, if we've retained an attorney and are participating in a case, that's certainly a very, very strong argument that we've actively participated. We've essentially sought to prove up our damages in that case, sought to prove up liability from the tortfeasor. Adds active participation in my book. But in other states, for example, there's a great decision in Texas for those of you who are claims adjusters. If you've gone out and expressly sent these two letters, one, I sent a demand letter to the tortfeasor saying, hey, we're pursuing our subrogation claim. Don't subrogate directly with the plaintiff's attorney, or put us on the check. Here's proof of my claim. That's active participation enough. In that Edminster case, which I've cited, which is a good case for you to write down, Allstate notified the tortfeasor of its subrogation claim, asked that the tortfeasor issue a separate check, and even provided medical bills to support its position. It also wrote to the plaintiff's attorney saying, you don't represent us, we're pursuing our claim, go ahead and don't go ahead and represent us, we're not going to pay you a fee. So that's great. There's a couple other applications for claims adjusters or in-house folks that you want to keep in mind. If we're arbitrating a case, there's arguments on both sides. There's authority on both sides that the arbitration will constitute active participation that will defeat the common fund doctrine. There's some authority that says the arbitration necessarily isn't presumptive that it will defeat the common fund doctrine. There's also some good authority for those cases where the attorney is actively litigating your ability to assert any lien. So if they're not cooperating with you, if they're not really looking out for your interests, the Lyons versus Geico case from Alabama says, well, the doctrine won't apply in those cases where the plaintiff attorney tries to defeat the lien. So keep that in mind too. Can a non-ERISA insurer under state law contract out of the common fund doctrine? This is one that I have researched extensively. I haven't found any authority that would allow a non-ERISA insurer to essentially insert a contractual provision that it's not responsible for attorney's fees and have that upheld by the court. And one of the reasons is that a lot of courts will say that while the attorney's common fund claim actually belongs to the attorney and not your insured, and therefore, even if you wanted to contract out of it, it would have no effect because it's an equitable claim brought by the attorney, not subject to your contract. So keep that in mind. I think that the contractual disclaimer of the common fund doctrine is difficult. I'd, of course, welcome a case to challenge and make some good law on this, but I haven't seen that to be able to recommend that. And then we're getting close to the end here. Finally, if you don't have any other way that you can argue out of the common fund doctrine, we've exhausted all of the arguments we just went through. You can always argue, and the courts are receptive in some cases, that the percentage of fee being claimed by the plaintiff's attorney out of your lien is unfair. Typically you're not going to be able to make a very good unfair argument if they're seeking a 33% reduction. That is basically the standard. But what I'm seeing more and more become the standard is 40%. I've even seen 50% in some states. And I think under those scenarios, you can certainly make an argument to the court that 50% reduction is just absolutely unfair as far as the common fund doctrine goes. So the Amica Mutual case versus Maloney has some language, although it basically says that upholds the fee agreement there. It basically says, look, if it's unfair, you can certainly challenge it, and I guess that's your last resort to challenge the court's application there. So again, I know I had to kind of speed through the common fund doctrine a bit, and maybe didn't get to cover everything regarding the made whole doctrine in detail for our 1-hour seminar here today. But again, if you've got questions, you want to specifically address certain facts or certain arguments in a jurisdiction, or you've got questions, just email me directly. We're also recording all the questions you've submitted today. I will make sure that we follow up with you on any questions that you have asked. Again, I apologize for taking up most of the hour here in my presentation, but and not maybe providing enough time for questions and answers. But I do thank everyone for attending. This presentation is going to be recorded and eventually available on our website for you to download, share it, circulate around the company. We've also got a number of other presentations that are already documented and available on our website. So feel free to check in with all those resources. And again, I really thank you for taking the time, and I look forward to hearing from you afterwards if you've got any questions. Also, if anyone out there is going to be down at the annual NASP subrogation conference this year in November in Orlando, let me know. I'd really like to touch base with everyone down there. If you're coming, let me know. if you'd like to join me for dinner, we're taking a group of folks out. Let me know. I'd be happy to get you on the list for that as well. Again, I really look forward to meeting you in person if you're coming down. So again, I will get back with you on those questions that have been submitted. And thank you, everyone, for your attendance. Take care.